Well, charitable giving comes in many forms, the most obvious of which is to write a check or give money directly to a charity and derive the satisfaction and benefit of seeing that money used at that time. In the estate planning context, often charitable planning is done on a delayed basis, meaning that a client will make provisions in their trust or their will, if they're just going to use a will in their estate planning, to provide for a favored charity. There is a tax benefit, of course, from giving either on a delayed basis or immediately. Sometimes clients come to me and they say, I'd like to form a private foundation. Well, private foundation sounds good. It's a very technical planning technique, and it requires a lot of maintenance going forward. So if a client doesn't have upwards of $3 million to initially gift and put into that foundation, I discourage them from doing so. But another way for them to learn how to give on an annual basis, like a private foundation, would be to create a donor-advised fund with a local community foundation. The community foundation is already established with the IRS and is a recognized public charity. The donor-advised fund is an agreement that the client makes with the board of that community foundation to give recommendations every year to the Community Foundation Board where to give their money. Thus, I could create the Jeffrey Zabner Donor Advised Fund at the California Community Foundation, seed it with an initial $10,000 gift and continue to gift to it every year, and then my wife and I and our children could meet once a year and say to the foundation, please give the money to this year, please give the money to the American Heart Association or the Cancer Foundation. This is a wonderful way for a family to get involved on a charitable giving adventure, which will ultimately result in including charitable giving and planning in their estate plan.